Your Honor, I agree with State insofar as this is a simple matter. Where we disagree is I think a scientist was needed. I think someone who actually has the technical know-how of how this violation report came to be. The State did have that standard of clear and convincing to prove that my client violated this. So far, all we have is a piece of paper that, at least for right now, is supposed to have been prepared by someone else who is not here to testify. There's no ability to cross-examine them on their expertise, on any notions of false positives, on any issues that a technical expert would actually know about the device. And without that, Your Honor, I think it's very clear that the State failed to prove their burden of proof that my client consumed alcohol. And I would ask that, Your Honor, again, not revoke the bond, keep it as is. My client's here. There hasn't been any warrants for his arrest issued since he's been coming to this court. And in the allegations itself of the underlying offense, there is no allegations of injuries or accident to persons. So again, just take into account that you need to take into consideration flight risk and safety of the community. Nothing that's been established here in this hearing or outside of this hearing should lead the court to believe that my client is a flight risk or a danger to the community. And with that, I'd ask that you not revoke the bond, Your Honor.
And Judge, these devices are used. Say it again. These devices are used all the time.
Well, their use all the time is irrelevant to needing an expert to testify on that.
I absolutely appreciate your tenacity. I have done everything in my power not to revoke his bond. He is on bond for a DWI in another county. He picked up a DWI here. He's had not one violation. On the first violation, I didn't take him in. He had a second violation. I didn't take him in. Now he has a third violation. It would be unreasonable for me not to. I told you that there was no tolerance in this case. You yet refuse to comply with bond conditions. I find by clear and convincing evidence that you refuse to comply with bond conditions, and I have bent over backwards not to put you into custody. But now we have a positive blow. We have someone who has testified to it, and I believe it. So I am now revoking your bond. He goes with you. He had positive THC, right?
Well, we sent him earlier this week.
He also tested positive for
THC.
marijuana as well.
Well, Your Honor,
This week.
that wasn't. Are we still on the record then? On that? Well, I would also want someone to come testify about that, Your Honor. But you know that I'll make. I know, but yeah. I know you already made your ruling. But I was ready to testify on that because they don't have anything on chain of custody on the test itself, on whether it tests cannabinoids, which delta 8, hemp. There are a bunch of things that are THC related that could pop positive for THC that aren't THC.
Regardless, we admonish him not to put anything in his body that doesn't have any delta whatever. Regardless, it's number 3 goes with you.